I would commend to you reading part of the loser's history. Read Brutus. He tells us that, he says, just read the plain language of the Constitution. It creates a court with an expansive jurisdiction, an expansive authority. It creates Congress with an expansive mandate, and they are going to work together, court and Congress, to run roughshod over the states. And that's exactly what has happened. And he says, writing way back then, it's in the text of the Constitution.
And the real fight was between Madison, who said no it doesn't and meant it, and Hamilton, who said no it doesn't with an eye wink.
Right.
Over here.
Yes, this is John McGinnis from Northwestern University. I guess this question is largely for Rick Hills, which is how relevant are the comparisons to other structures of government elsewhere? The United States government, we have people all elected from individual states or from districts, and in comparison, they're not elected from lists. It's not a parliamentary system. We have weak political parties, and so that means that the local focus of our elections means that there's a tremendous incentive, you might see as a tragedy of the commons, for the local interest to overfish the federal budget. And that is a dynamic which isn't constrained by other characteristics. And I think you absolutely correctly point out, well, maybe we could have the president as the actor constraining this. But the difficulty there is the president has many other objectives on which he's judged. He's likely to trade those off and allow them to go with their local pork barrel spending. In fact, the president who didn't recognize that and came in and vetoed all of the water spending, the local water spending, as his first act was Jimmy Carter, and many people think that that actually was one of the acts that destroyed his own presidency. So I just wonder whether you could comment on the political dynamics of our structure and why that might lead to a need for additional constraints on this localized spending.
Keep in mind, Germany has half of its Bundestag elected from districts, not lists. So, it's hard to do the comparisons. But yeah, I agree that universalism, this is the dynamic that you're pointing to, is difficult. Universalism is simply the dynamic that everybody loves their congressperson but hates Congress. And the reason they love their congressperson is because the local projects funded by the feds are highly visible and attributable to that congressperson. You can cut a ribbon for it, and a balanced budget is not something you can cut a ribbon for. And so each representative has a huge incentive to despoil the budgetary commons. My only problem, I agree that's a huge problem. That's why I think some kind of enforcement of federalism norms on spending is a great idea. But the notion that Judge Sutton and the rest of the Article 3 judiciary can solve this problem strikes me as just crazy.
Ouch.
and this is not to accuse Judge Sutton of incapacity, but simply of modesty. Right? He was appointed to be an Article 3 judge, not the Secretary of the Treasury. And so, and I want to clarify something. I am not accusing the Sixth Circuit of partisan bias. I'm accusing them of common sense. If you're given a document that says, do the right thing, make good policy, and a judicial doctrine, Pennhurst doctrine, that says, if something's ambiguous, favor the states, and you have no definition of ambiguity, there's no concept that's more ambiguous than the concept of ambiguity, then it's natural for judges, it's obvious that they have no choice but to fall back on policy priors. Now, I happen to agree with Judge Sutton's opinion, because I think, wisely, he set Pennhurst aside and said, I'm not going to simply overwhelmingly favor the states, I'm going to engage in straight statutory construction. And he reached the general position that it would be insane to construe No Child Left Behind as having no benchmark provisions, as exempting states from benchmarks. And I think that would be insane. But it's not insane in the wild, wacky world of judicially enforced federalism, where you can essentially have a blank check to declare statutes to be ambiguous, and then favor the statutes that favor a policy preference you like. So I think that the only way Judge Sutton could write a sane opinion in that case is by setting aside judicially enforced federalism norms and saying, I'm going to engage in straight statutory construction because I do not think that Pennhurst is a blank check for favoring the states whenever a judge finds a statute to be minimally ambiguous.
Well, as tempting as it is to end there, I'm going to allow one more question.
Thank you, and I'll keep it brief. Roman Buehler, former elections counsel to the Committee on House Administration. And my question is to Professor Feeley. You talked about a fear of concentration of executive power, but basically described yourself as a skeptic of federalism. And the dynamic that I see going on in election law is that Congress, especially the liberal majority, is moving to centralize election power in Washington. But the result of that centralization is not to increase the power of Congress. That power mostly resides in federal agencies, and those federal agencies are all subject to the recess appointment, which, most agencies have power consistently over a period of time. Election agencies have power concentrated during the election period. And so you're creating a situation in which the president, through the recess appointment, potentially has control of the election commission. And that didn't work in Zimbabwe, it doesn't work in Russia, it doesn't work in Afghanistan. Does that give you any pause when you think about the defects of federalism versus the risk of increased presidential power?
Again, it may be that I grew up in the South in the 50s and remember how local, I remember landslide Linden, and so I don't have the great faith in local electors. I think, let me just back up and say, I think we are a national polity. No one will fight or die for the state, or even get in a fist fight very much for a state anymore.
Go to an Ohio State-Michigan game.
Well, yeah, but you can get the football game, but I don't think that's a state, because we can get in a fight at Cal with Stanford or USC as well, and they're intrastate. So I think there are heated competition, but I think that we are a national polity, and we have to confront that we're a modern administrative state. The idea of recess appointments, the idea of subversive practices to manipulate the administrative process is obviously a bad one. But I think we ought to tackle policies direct on. I think it makes sense to have political safeguards of federalism. If a president doesn't like something, let him veto it. Yeah, and I think what we are doing in trying to protect federalism is really through the judiciary, is really letting our members of Congress off too easily. We think they are cowards, and we're institutionalizing their cowardness, and so we're giving elected officials to try to supervise them. I think we need a more robust politics, and I don't think we need a political safeguards of federalism so much as a political safeguards of the fiscal purse and a political safeguards of responsible government.
Well, thank you. We had 4 excellent panelists, and I'd like you to join me in thanking them for a great presentation.